Hi, good afternoon, everyone. This is Rajiv from the law offices of Rajiv S. Khanna, PC, immigration.com. This is our bi-weekly community conference call. Every other Thursday at 12:30, you can dial into 202-800-8394. As usual, I'm going to begin first with the questions I consider frequently asked questions. There's only a couple of them today. So let's see. The first one was, how many days can I stay in the USA? Oh, let me just make sure everybody can hear me okay.
The conference is now in conversation mode.
Can you all hear me okay, guys? Can you all hear me okay?
Yes.
Okay.
Yes.
Excellent.
Yes.
The conference is now in presentation mode.
So let me begin with this. How many days can I stay in the USA after H-1B denial? I wanted to have a little bit of a detailed discussion on this because this question comes up so many times. And there are so many different ways to approach this. I'm not sure how I can give you a comprehensive overview because there are several variables. So let's begin with the question posted by Nick. He says, she says, I moved from company A to company B, September 2017 on the basis of a receipt. So I file a transfer, I join the new employer. I got a denial from company B. They told me to stop working. My company B again refiled my H-1B. Now let me stop here for a second. Nick, this may not apply to you, but this is of general interest to the community at large. The new regulations that became effective on January 17th, 2017 now clearly say this. If you were working for employer A, employer B filed your H-1B transfer, you joined employer B using the receipt, they got an RFE further along the line, the H-1B transfer got denied. Government says you can go back and join employer A as long as you never worked without authorization and as long as the employer A has not revoked your H-1B, and lastly, the job that they had gotten approved for you is still in existence. They still want to take you back. That's kind of a common sense reading, but the basic language of the regulation says you can go back to the old employer and the old job. So that's an important point to remember. You go from A to B with a receipt, B gets denied, you can go back to A. Now, this is very tricky. Company B wants to refile. The problem is, it's almost, well, it's best to assume, I'm struggling with a bunch of concepts and trying to articulate them so that not to confuse the issue. It is best to assume that once your H-1B through company B is denied, unlawful presence has started to run. So that if you are unlawfully present in USA for 180 days, no matter what was pending, once the unlawful presence has begun to run, it's very difficult to stop it. Only a timely filed I-485 application can stop its running under the current rules. Tomorrow what the rules are going to be, I don't know. So assume that once the transfer is denied, unlawful presence has begun to run. So even if the employer B files the H-1B again, unless it gets decided within 180 days, you've got to leave USA. So how long can I stay? In this case, you can stay no more than 180 days. You're still not legal. Discuss with your lawyers what they recommend. But after 180 days or at 180-day point, you become automatically barred from entering the USA for 3 years. So first situation was easy. Transfer A to B, B denied, go back to A. Second situation, transferred A to B, B got denied, B refiles, unlawful presence has started. So therefore, B case, the refiling should be done premium processing. So his question or her question is, if my new position also got denied due to specialty occupation, how many days do I have to? So I gave you the 180 days. There's no 60-day grace period from denials. That's a misunderstanding. The 60-day grace period is only available when your job is terminated, not when the case is denied. At least that's not how I have read the regulation, nor have I heard anything from USCIS that says they will allow 60-day grace period in case of a denial. This is in case of a job termination. Also, your I-94 there must be time remaining on your I-94. So let's say I got laid off from my job on January 1st. My I-94 is good till February 1st. The 60-day grace period would have gotten me to January to February, February to March, 60 days to March. But because my I-94 validity is only 30 days, I will only have 30 or actually less than 30 days till the I-94 expires. So I-94 or 60 days, whichever is shorter, and that too if the job is terminated. By the way, even if you resign, that principle would apply. That's the way I see it. Okay. So going back to the question of how long can I stay, I gave you the first scenario, I gave you the second scenario, and the third scenario now is how does the grace period apply? And I think I've made it clear. In the expert opinion letter you are asking me, that's a very difficult question to answer because there are again so many variables. See, essentially, even though they split it into 4, but there are really 3 ways to prove specialty occupation. Either it is the industry standard, or the particular job is so complex that it requires a degree, or that the employer has never hired anybody with less than a degree for this job, plus some justification for that requirement. So there really are 3 ways. Now, which way you are approaching, it all depends on that method or methodology, what kind of evidence you will need. I would have to leave that to your lawyers to decide. Okay guys, I have discussed this frequently asked question. If there are any follow-up questions, press *6. Is it *6? I'm sorry, *5. Press *5 on your phone if you have any follow-up question on these issues that I discussed. *5. Okay, I will go on to the next frequently asked question. Applying for an H-1B transfer while an extension request is under RFE. Now, this is again an issue that comes up quite frequently. So we've got a transfer of H-1B pending from A to B. A transfer request pending from A to B. While the request is still pending, one second. I'm in a conference call. While the request is still pending, I want to do a transfer. So I've got an extension pending. I want to do a transfer. Now there are 2 possibilities here. You know that you can apply for an H-1B extension 6 months ahead of time. So let's say I applied in January and my H-1B is expiring in June. If I apply for a transfer to another employer while my original I-94 is still valid, so if I apply any time before June when my I-94 is expiring, I'm really applying within the life of the previous H-1B and the extension is still pending. That's fine. That's no issue at all. But what if you file after your I-94 has expired? So your extension is pending in the month of July, August, September, whenever, after June, when your I-94 expires. Now your status depends upon the bridge, which is the previous H-1 extension request. In these cases, what happens is, on the date your transfer request is decided, unless your H-1B is actually approved, the extension is actually approved, government will probably ask you to go outside USA for visa stamping. So if the extension request is still pending or decided against you, you will have to go outside USA for visa stamping. Let's look at the questions Vijay has written. 2 questions. I am in USA on my work visa from June 2007. My current H-1B is valid till August 2018. Okay. I have applied for extension on April 10th. So expiring August, applied April. One US citizen kid, one H4 kid. Question 1. If I get RFE after August, can I apply for H-1B transfer with other employer? I just covered it. Yes, but you probably will have to go outside USA unless the case is already decided in your favor when the transfer application is decided. Question number 2. Living in USA 11 plus years doesn't help you, and I'm not sure how you would apply for relief from deportation. I'm not at all sure how that would apply. And as far as political asylum is concerned, unless it is a genuine application, that would be fraud. And political asylum usually means that you have a fear of death, etc. if you were to go back to your home country, persecution basically. So unless you have a genuine case, you of course should not apply for political asylum. And I'm not sure that any kind of relief from deportation would apply to you just because you've lived here 11 plus years. I am not quite sure how, in your case, that law would help you out. Okay, I don't think it would. Any follow-up questions on this frequently asked question? Nothing new, please. *5 on your phone. Press *5 if you have a follow-up question. Okay, I think these were the only frequently asked questions we had today. So let's get started on the remaining questions. Folks, people who are just joining me, I want to make it clear we're not going to have time for new questions. I'm only going to deal with the questions that are posted and the follow-up questions on those questions. Ganesh says, I am in EB1C category. I want to know about EB1C category. I'm an H-1B with the employer since last 8 years. Got transferred by the same employer from India. I was working for them in India for 2 years, then came here in H-1B. I was working as tech lead manager across multiple centers. That sounds like an L1A/EB1C type job. They initially applied for green card in EB3, got the I-140 approved. They've also applied for EB2. I-140 is in process. Am I qualified for EB1C? I think you are. Because I have to review the regulations again, but I'm pretty sure what the reg says is this. If you were working as a managerial employee and then you entered USA, within the last 3 years before you entered USA, you should have been working as a manager for at least 1 year for this employer if you continued working with the same employer, even though on H-1B. So I think you would qualify for EB1C at least time-wise. Would you qualify based upon your job description? I don't know because I don't know what your job description is. Okay. So yes, it is definitely worth a shot. *5 if you have a follow-up question on this, guys. *5. Okay, this one is, let's see, from New York. Yeah, New York, go ahead, please. I can hear you.
Hi, Rajiv ji. This is Ganesh. I'm the one who posted the question.
Yes.
And thanks for taking the call. And my follow-up question is that if any issue, let's say that my employer go ahead and files that EB1C while I'm here working in H1B, and if they file the EB1C and if there is any issue and for some reason if it gets rejected, will I be still able to use my EB2 green card and stay here and work?
Absolutely. Because as long as we are not saying something that is either untrue or contradicts the history that you already given the government in your EB2 and EB3 filing, I do not see how an EB1C filing can hurt you. Of course, let your lawyers look at the case, look at the background, and make sure that they do their due diligence on your paperwork before they file the EB1C. But theoretically, at least, there is absolutely no problem.
Okay, thank you. And then one last question on this, Rajiv ji, that so since I have like already my EB2 I-140 is approved, once they file the EB1C, can they port my current priority date to the EB1C?
They can port your EB3 date to the EB1 too. Either one, whichever is your earliest priority date, it can be ported.
Oh, okay. Thanks a lot. Thanks a lot,
you're
Rajiv ji.
welcome.
That's
You're
it.
welcome.
Thank you.
Okay. I think there's another one. Huh. Two people with the same issue. I can't tell where this one is from. Give me 1 second, guys, while I figure this out. Delaware. Okay. Delaware, you have a follow-up question? Go ahead, please.
Yeah, hi Rajiv ji. I have a similar type of question. I haven't posted it because it looks similar, but can I like to go ahead?
Of course. Any follow-ups
yeah.
on any topic that I'm discussing are fine.
Yeah. So like the same thing, like I have a EB3 140 approved and I am currently on H1 and my company filed EB1 also and it's basically denied for the reason they gave is managerial capacity.
Okay.
Now, my question is, I got the EAD while I filed the EB1 and now because my EB1 is denied, like I think the EAD and the advance payroll is invalid now. So my question is, currently am I out of state or I have a valid, because I have a valid H1 which is approved till April 2019.
Okay, hang on 1 second. Let me answer your question. I understood your question. So the question is, if I get an EAD approved, does it overrule an existing H1B? The answer is no. Approval of an EAD does not nullify the existing H1B. Using the EAD does. How do you use the EAD? One way to do it is to change your I-9 paperwork showing that you are working on EAD, not on H1B. Another way is if you took a second job. Another way is if you moved locations relying upon your EAD instead of your H1B. So as long as you are still working under the H1B terms, approval of the EAD and then subsequently revocation of the EAD has no effect on your H1B. Okay?
Okay, thank you. And last question, like as you gave 3 reasons, like when I moved to EAD, I never used in any of those 3 cases, but actually when we filed, my wife also got the dependent EAD.
She's fine as well. She's fine as well.
Okay, only thing we use is to get our SSN. That doesn't cause any problem.
But Ganesh, no, you're not Ganesh, sorry.
No,
the thing is,
right.
Your wife's use of the EAD has no effect on you.
Okay.
Okay.
Got it. Thank you so much.
You're welcome. Good luck, sir.
Thanks.
Okay, let's go on to the next question. Once again, a couple of people just logged in. Guys, I won't have time for new questions. I will only do the questions that have been posted and those questions that follow from the posted questions. Okay, now next one is Roberto. See, Roberto, the problem is from your situation, you were in the armed forces and then you did not report back, which means you deserted. And the question is, what happens to my permanent residency, which was obtained through mom's VAWA petition? And the answer to that question is, I do not know what kind of crime or violation desertion is. Okay, so if desertion is a military crime, I have to look at the implications. I don't know the answer off the top of my head, but the normal law is that if there is a felony and there is an element of moral turpitude, your green card can be taken away, even if you have it. And the fact that 5 years of limitation are over, that might render you immune from prosecution. But my guess would be that it does not render you immune from the immigration consequences. So what I would suggest is that wherever you are located, talk with a local immigration lawyer and talk with somebody who does deportation cases, so that if there is any issue, they can represent you in the local court system, in the immigration courts. We are located in Virginia and we don't do cases in immigration courts. We work only in federal courts. Okay, So not much I can tell you other than go talk with a local lawyer, and don't assume just because the limitation on any prosecution for desertion is over, you are also immune from immigration consequences. I'll move on to the next question, folks. Skant Ganeshan says, this is regarding the green card waiting time to file I-485 and also getting green card for EB2 and probably EB3. Many articles are saying it might take decades. I don't understand that 150 years calculation. I haven't really looked at it because that just is not right as far as I can tell. But maybe I'm wrong. I'm always willing to be proven wrong. As long as you can show me the data. It's taking 10, 15 years almost. Why would it take 151 years? I don't understand that. Now, your question is, does an immigration law firm like yours have any idea how this absurd time period might change? And the answer is, I do not know. The only thing I can tell you is that there is a drastic increase in denials of all kinds of immigration benefits. Maybe that will slow things down, but unless Congress acts to do something about the backlogs, I don't see how it can change. *5 if you have a follow-up question on this. Okay. Once again, people who are just joining us, I will not have time for new questions. USDC says, I'm a US citizen. My sibling is here on a student visa, 23 years old. Can I adopt? No. You cannot adopt anybody over the age of 14. So once they turn 14, you can't adopt them under US immigration laws as far as I know. And also, there is a lot more to adoption than merely just choosing somebody. So first of all, this person, your brother or sister, is aged out already for adoptions. Next question from New Andhra. Can a derivative with the EAD be outside USA on educational purposes? Sure. You have to just make sure that it's not the EAD, it's the advanced parole that keeps them in status, or that keeps their 485 in the play. So if they are outside USA and their advanced parole expires, chances are they have to refile the 485 at some time in the future after coming back to USA in a legal status that allows the filing of the adjustment. So this can be tricky, and they cannot travel out. So let's say they are outside USA for 6 months. Now their advanced parole is about to expire. They've got to come back, apply for advanced parole, and wait until it gets approved. If there is an emergency, they might be able to get an expedited advanced parole in the local office. But unless that is approved, they can't travel outside USA until approval. *5 if you have a follow-up question. So really the answer is they can, but there are some practical issues that you've got to consider. Okay, let's see. This one is a voice over IP, so I don't know where you're calling from. But go ahead with your question, please.
Yeah. So this is Rahul Surana. My daughter, she's 10 years old. Her advanced parole has got denied because she traveled outside of US while the application was pending because of emergency situation. Now she is in India right now. What is the way? What is the alternate for me to bring her back to US? My green card is filed in EB1.
Are you currently on H1 or L1A? What is your current status?
Yeah, I'm on EAD. My L1 got denied, but I'm on EAD now, and my green card is filed in EB1.
As far as I know, you cannot bring her back because you don't have any status to bring her back on. There are things like travel letters, sometimes humanitarian paroles that might make it possible. You can certainly try humanitarian parole. It may or may not allow her to file for adjustment of status. Have your lawyers look into that. It's a little tricky. Okay. So the answer is no easy way. Have your lawyers look into humanitarian parole and see if the travel letter route works. I don't think it will, because the problem is in order to file 485 you have to be in status, and usually parole is not considered to be status, but humanitarian parole might be. And lastly, you can always convert her green card to consular processing so that you get your green card here and she gets it in India. All right?
Okay. Okay. So if she cannot come to US, she can still give interview here in India and get the green card.
It's not an interview. You have to convert it to consular processing. Yeah, it can be done that way. Yes.
Okay. Okay.
Good luck.
Yeah. Just one last question on that is, the attorney suggested to apply for a tourist visa. Is that a viable option?
My advice would be to change lawyers. Okay?
Okay.
Good luck, sir.
Okay.
All right. Bye-bye.
All right. Thank you, sir. Thank you.
Okay, some things just don't make sense, so hence the advice. All right, let's go on to the next one. This question I probably answer almost every other conference call. Can an H4 visa holder trade stock and earn money? And the answer is, I am guessing. I can't say that I'm right or wrong, but I'm guessing as long as it's not day trading, active trading every day for 5 hours, if you just invest in stocks and leave it there and occasionally churn your stocks, I think it's okay. I don't think that can be considered to be active work. That's your own investment. But I think if you're doing it as a day trading, I fear that might be considered to be unauthorized employment. I can't say that I'm right, but this is my guess. *5 if you have a follow-up question. Okay. Let's go on to the next question. This is TN visa. And here the question is, if I'm a business consultant on a TN visa, should I be traveling? I can tell you this, that they are trying to make TN visas very difficult. I have a client who has been put through such a ringer, and government is obviously wrong, legally wrong, but that doesn't stop them from trying to delay you or deny your case. So yes, I agree with your lawyers that if possible, avoid travel. Simply because, not because there's anything inherently problematic about TN visas, there's something problematic about the current environment. So yeah, I don't know what you are reading, but I definitely agree with your lawyers. *5 if you have a follow-up question. *5. Okay. NK Gokna says, husband is on H1B, approved I-140 with company A. 6 months have passed. He's on 7th year of H1B, planning to move to company B. If for some reason before we get approved I-140 from company B, will he be eligible to move to company C? Yes. Once your I-140 is approved, you are entitled to your priority date, even if the old employer revokes the I-140. Once the I-140 is approved and it's not revoked, you can of course keep changing as many employers as you like and keep getting H1B extensions. But if the I-140 is revoked by the old employer before 180 days of approval, you lose the right to keep extending H1B even though you still keep your priority date. If I-140 is approved and stays approved for 180 days, you have unmitigated right to keep changing employers and getting extensions beyond 6 years, even if the old employer revokes your I-140. So I hope that clarifies things. *5 if you have a follow-up question. Okay. Ram Kumar, and Ram says, last month my I-140 has been approved. Now I have full-time offer from client and the client will start the green card process next month. My employer didn't share the I-140 approved letter and they are not going to share it. Can I get a duplicate copy? You cannot. I don't know of any way to do that, but I think you can definitely try applying for Freedom of Information Act request and asking for a copy of your immigration file from the government, from USCIS. And I have seen cases where they have given approval copy. Now, there have been some changes in the way government reviews the beneficiaries of I-140s. You can try contacting USCIS customer service and see if they'll give you a copy. I don't think they will, but because of this churning in the way government treats employees under I-140, I don't know if you might be able to get one. So call USCIS and file Freedom of Information Act request. *5 if you have a follow-up question on this. *5. Okay. Rajiv Dutt says, I'm in USA since 2003. In 2008, I joined Company A, which did my green card application under EB3. Priority date is 2008. It's been 10 years. And I completed my master's and worked with the same Company A, but now I'm a team lead. So this is a question about what happens to my green card case if my job description changes. And the answer to that question is, if there is a substantial change in your job description, that's a question to be decided with your lawyers. I would think that you would have to restart the green card. And if you have your I-140 approved under the old case, you can, of course, transfer the green card to the new job. And that's the way I would do it. Okay. And you can use the master's degree if the job being offered to you under the green card is substantially different from the job you were doing with the company so far. Okay. *5 if you have a follow-up question. *5. There's another question further down, I think, with a similar issue. Change in job description while the green card is pending. So if it is, see, once you reach the I-485 stage and your 485 has been pending 180 days, you can change jobs, job descriptions, companies, departments, it doesn't matter. But before that, you will have to restart the green card if there's a substantial change. PG2617 says, I have two questions. I'm on H4. I have two old approved H1B from employer A good till 2018 and employer B good till 2019, but both are withdrawn. Now I want to work again. Once I get a suitable project, I want to change to H1. You see, I don't know if you ever worked on H1 and you got change of status. See, if you've received change of status to H1 or H1B visa in the last 6 years, you should be able to go back to the H1. But you cannot join the work location based upon the receipt. That is not going to work because you're on H4. So no, you cannot join with the receipt. Can two employers file for simultaneously file for an H1B? And the answer is yes. It's not really called an amendment. Yeah, actually, if you get an approval, let's say, of an H1B from one employer A, and then you want to file a transfer through two different unrelated employers, I don't see any problem with that, or even related employers for that matter. So the answer is, 1, you cannot join with the receipt, and 2, you can have simultaneous petitions filed. But I have had an earlier discussion on how they treat cases filed while intervening cases from which you are deriving status are still pending. Worst case scenario, you might have to go for visa stamping. *5 if you have a follow-up question on this. *5. Naginder Gogna, wife got her EAD extended. There's an uncertainty around EAD. Yeah, H1B gets approved but visa gets rejected, will her EAD still be valid? So if you have an H4 visa and an H4 EAD and you get an H1B approved without change of status, if she goes outside USA for H1B visa stamping and they don't cancel her H4 visa before they start the H1 consideration, denial of the H1 does not affect her H4. So the only variable that can cause a big issue is, do they revoke the H4 before they consider the H1? As I recall, their standard operating procedures require them to cancel out all existing visas before they consider a new visa. Okay, but they don't often do that. I could be wrong, but this is what I remember reading long time ago, and I would have to double check it. But if they don't revoke the H4, then denial of the H1 should not have any problem for the H4 visa or EAD. Okay, and you would not have to apply again. *5 if you have a follow-up question. *5. Just Dave, working for company X with job A, planning to join the same company. Yeah, this is sort of the same question. With job B, 60% same, 40% different. I think 40% is substantial. So you will have to file a new labor in I-140. But you will be able to inherit the priority date of the old approved I-140. *5 if you have a follow-up question. *5. See, your job changes become secure only after 485 has been pending for 180 days. Venu S. Krishnan, or is it Venus Krishnan, says, I have some updates. So apparently there were some questions the last time. And the I-140 EB2 filed RFE. So the important date is that on June 4th, 2018, which is a few days ago, the I-140 was approved. So H1B 6th year extension also approved on June 28th. It's valid from November 29, 2018 until 2021. When will I be able to change my employers? Well, after 180 days, you become safe. But here's another way to approach this. If you are a little bit of a risk taker, what you can do is, if you are ready to change employers now, have a new employer file for an H1B for you. You still have an I-140 approval. They will get approximately 3 years for you, good till 2021. Once the H1B is approved, you can join the new employer and have them start another green card for you right away. Normally, even if the old employer revokes your I-140, USCIS is not going to revoke the H1 3 years they have given you for the new employer. In 3 years, if you get your green card filed, you are safe because you can use the new green card as grounds for further extension after 1 year of filing. So you can do it that way. Your priority date will remain yours once I-140 is approved, unless there is some fraud or revocation by the government on those bases. So even if you leave and the employer revokes your I-140 before 180 days, you will still keep your priority date. The points that you keep in mind is just talk with their lawyers and make sure they understand they've got to start the green card right away. I don't think there is anything else much to think about. Okay. *5 if you have a follow-up question. *5.
Hello.
Yes, I can hear you. California, go ahead, please. Yeah.
Hey, Rajiv, this is I'm actually hearing my voice again.
Hello.
I
can't hear you.
Yeah. Can you hear me?
Yeah. I think you got cut off there for a second. Go ahead. How can I help you?
Rajiv, this is Pramod. I think a couple of calls back we had we had a talk about this. So I have one question. If I change my employer to this, I have this another employer who wants to hire me, and after 180 days, if I change job to him, transfer my H-1B, like get him petition within H-1B, and then after that, do I need to go and tell him to file my green card again?
Yes.
Or
yes. Yes. Yes.
He has to, right?
Yes. The only time you will not have
so
to
does not, if
hang on. The only time you will not have to file the green card is if your I-485 has already been filed and pending 180 days. And you're not at that stage, so therefore, green card will have to be started again, but you will carry the priority date of the old case.
Got it. And so there's no possibility, there's nothing, the employer, say if I was on the second year of my extended green H-1B, then changing employment is not a good option, right? Because you don't really have enough time to apply for the green card, the PERM and the I-140 all over again.
Why? Because you have unlimited right to keep extending your H-1 because of the earlier approved I-140. What is the problem?
Okay.
Okay.
I was thinking of this scenario, like now my H-1B is going to expire in 2021, right? If I say if January 2021 I change my employment to some other company, and but then the other company has to start filing my green card right away.
Right.
Can they, on that basis, when they apply for my PERM and I-140, they can extend it, right?
Right. Here's how it works. There are two kinds of extension. Yearly extensions that are given either when your green card has been pending for 1 year, that's guaranteed, and two, if your I-140 is approved and your priority date is current, then you only get 1 year extensions. So the race is really to file the green card within the first 2 years of your 3-year H-1.
Got it.
Okay.
Okay, sounds good. Thank you so much.
You're welcome. Good luck. Yeah, immigration law can drive you crazy. There are so many variables. Ray 1111, I have to decline to answer the question definitively because I haven't really looked at the travel ban. I haven't had occasion to look at it. So I don't really know how this is going to conflate with the K-1 visa. I'm sorry, I really have to look at the travel ban issues. Can't really answer your question. If I get the chance, this weekend is going to be very busy. I doubt very much. But you might want to look around or speak with somebody else. I would have to review the law. Can't answer it. Samir says H-1B transfer company A to company B to company C, complex situation. I moved from company A to company B in November 2017 based upon a receipt. May 18th transfer got denied. Company B refiled my H-1B, premium processing, RFE again. Company C wants me to join. Well, shall I transfer to company C? I've discussed this matter in quite some detail today. I'm not sure I have anything else to add. In any of these situations, and I don't think the 60-day grace period quite works the way your company is suggesting. There is a 10-day grace period after denial, but I'm not sure there's a 60-day grace period. Actually, yeah, I might want to add that to our earlier discussion that there might be a 10-day grace period, but I don't know how to answer your question simply because I don't think 60-day grace period applies like that. I think you have a 180-day unlawful presence problem that you should watch out for. I don't see any problem in filing for the transfer. Make sure you are keeping an eye on the 180-day period after denial. Also be prepared to go outside USA for visa stamping. That's the worst case scenario. What else can happen? And if you go outside USA and you get stuck there, make sure that the company C is ready to send you work to your home country. If it is India, to India, you can work off-site for them until the visa gets approved. Star 5 if you have a follow-up question on this. Star 5. Okay. Next question is from Kuldeep. PERM is approved, planning to apply I-140. I've applied my PERM with company A, future employer, currently working with B. The job title was business analyst in the green card. I had mentioned business analyst, which was the same as my H-1B LCA, which is different from my company B position as associate consultant. Well, I'm not so sure that the job title makes such a big difference as long as the job description matches the job description given in PERM. So really it is the job description that is pivotal. I think you should be able to argue your way out of any problem. I'm hoping that's the way it would be, because it's really the job description, not the title alone. So even though the company calls you associate consultant, but your job title is really that of a business analyst, which is basically like a systems analyst, I don't think that should be a problem. Okay. Star 5 if you have a follow-up question. All right. Let's see. This one is from New Jersey. Yes, New Jersey. Go ahead, please. New Jersey. Go ahead, please. Hello.
Oh, sorry, I was on mute.
Okay. Yeah, go ahead.
So, my question is like, since this, whatever we are talking about, this is of my current company. So, they are saying that the title discrepancy will impact, because my current employer has given me exactly same description, skill set and token.
I don't think it will impact. Go ahead. Okay.
Okay. Thank you. Thank
You're
you
welcome.
very much.
Good luck.
Thank you.
Now, the last question for the day is this. I work as a senior project manager, and my company is planning to send me to India, Canada for 1+ year, but I will get salary in USA only. You have some issues that I would have to research. I can't tell you off the top of my head. So, if somebody wants to do an EB-1C, but their salary is being paid in USA, is that a problem? I prefer the salary to be paid in the country where you'll be working. And I also prefer that you be controlled by a branch of this company outside USA. So let me give you an example. Let's say the branch of your company or the parent of your company is, I don't know who has their hand up. I will not be doing any new questions. Please put your hand down. I have no time for new questions today. Sorry. I announced that in the very beginning. Okay, so this is the last question I'm going to be doing today. If you have any follow-ups on this question, I'll be happy to answer them. No new questions. Sorry. Okay. Again, you have your hand up. Leave it down for now. I'll ask for follow-ups. Okay. So, if you are working in India or you are working in Philippines, but you're being controlled from India, I think that's okay. That's an employer-employee relationship. But if you're being controlled from USA, I would have to research the law and the decisions from the government, what they say. It's not an easy answer I can give you. If your company doesn't have any offices in India, Canada, and you just have an offshore vendor, I don't think that's going to work. But can it work if you're an independent contractor outside USA? I do not know. I don't think so. I remember reading some cases where there were some weird twists in the law that these kind of situations were made to work. I don't know what those situations were. I would have to review the law. Can I file 2 green cards in parallel? Yes, you can. Will denial of one affect the other? And the answer is no, as long as they are both made in good faith and there is nothing mutually inconsistent about those filings. What is an O1 visa? Oh, you can research that. You don't need for me to tell you that. An O1 visa is reserved for people with extraordinary qualifications, which means pretty much the top guys in their own field, guys or girls. So it's not really available to most people. I know that even though I've been practicing law for 30 years and I've got, I believe, good qualifications, I don't think I would qualify for O1 visa. So that's my estimate. *5 if there's a follow-up question on this, folks. Okay, I see that there is one from Virginia. Virginia, go ahead, please. Yeah,
hello.
Yes, I can hear you. Go ahead, please. Go ahead.
Rajiv.
Yes, sir, I can hear you.
So I actually previously I pressed the *5 for one of the question, like for from company A to company B and to company C.
Okay.
Just only one question in that. The question you already told that I can go to the employer A in that option, and in the company B, then if again they already refiled my RFP and the RFP response will be come by next 2 weeks. So I'm completing my 60 days from the first denial on the 14th of July.
Okay, hang on.
So, but meanwhile, I got one.
There is no 60-day period like that. No. I don't know who is advising you. Talk with a lawyer. Hang on. Have a one-on-one, sir. Let me finish. Have a one-on-one discussion. Have your papers reviewed. Have somebody look at the regulations for you. I do not believe the 60-day grace period applies in denial cases.
Okay, so my attorney is saying that you don't have any 60 days, but still, if this denial will also come on denial, like on suppose July 20th, if this RFP will also got denied, then you need to leave the country as soon as possible. They are not saying that you need to leave the country as soon as possible, but as soon as possible they are saying. But meanwhile, I got one company C, they are ready to file. I got a project also, but they are
haven't I covered this question? What are you asking me that is new, sir?
So just one question is that if company C I already got, so they can file my H1B any day after the 60 days also, and I can work on the receipt notice, or I need to take
why do we keep talking about 60 days? There is no 60 days. Not for you.
Okay. Okay. So company C can file my H1B.
Because you are out of status, I have my doubts whether you can start working on receipt. I would have to look at the regulations, but in my opinion, again, without looking at the regulations, you have no 60-day grace period. You might have a 10-day grace period, and you definitely cannot start working if you are already out of status.
What is 10 days or 180 days?
There are 3 different periods: 10 days, 60 days, and 180 days. 180 days is unlawful presence. 10 days may be available if after denial. Look at the regulations. Don't know the answer off the top of my head. 60 days are for those people whose I-94 is still valid and they got laid off or resigned unexpectedly. Okay.
So in my case, my I-94 is valid. So in my case, what is my 10 days, 60 days, or 180 days?
I don't want to answer your questions until I've reviewed your paperwork. You may want to set up a consultation with me or talk with your own lawyers. You've got your lawyers. I have given you a general outline. I would have to look at every detail of your case, the dates of denial, I-94, was the previous H-1B withdrawn? Is it still not withdrawn? So I can't really answer all your questions in vacuum. Generally speaking, after a case is denied, there might be a 10-day grace period. Look at the regs, have your lawyers look at it. There is no 60-day grace period, and 180-day grace period. It's not a grace period. It is the point at which you get automatically disqualified for 3 years. Okay.
Okay, so means I can leave the country before 180 days.
You can leave. Yes, absolutely. All right.
Okay.
Good luck to you, sir.
Thank you. Thank you, Rajiv.
You're welcome. All right, folks, I've got to run. Thank you all for being here. I always enjoy speaking with all of you. I'll be back in 2 weeks. We'll talk then. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.